1 in 4 homebuyers will make at least one of these 3 mistakes and won't realize the damage until months after signing the paperwork. By then, the loss has already happened and there's not much left to do about it. The worst part isn't the money lost. It's the feeling of having done everything right. You visited the house, liked the neighborhood, talked to the agent, signed the paperwork with confidence, and still fell into a trap that no one explained beforehand, because no one stopped to explain it. After more than 15 years representing buyers, tenants, and homeowners in real estate disputes across the United States, I've noticed a pattern that repeats itself constantly in practically every state in the country. These aren't complicated scams or elaborate fraud schemes. They're 3 simple, almost invisible mistakes at the time of purchase that attorneys like me watch destroy entire families' budgets year after year. What strikes me most about these cases isn't the amount of the loss, even though it often reaches tens of thousands of dollars. It's the fact that, in nearly every case, the person had every ability to avoid the problem. They simply didn't know they needed to pay attention to that specific detail, because no one told them before the signing. These 3 mistakes don't depend on bad faith from the seller, and often not even from the agent. In fact, most agents don't even realize they're pushing the client toward this pitfall, because they aren't trained to think like a lawyer either. The agent thinks about closing the sale. The bank thinks about releasing the financing. No one in this whole process is thinking exclusively about protecting you, the buyer. That's exactly where the problem lies. Every person involved in buying a house, the seller, the agent, the bank, has a specific interest in closing that deal as quickly as possible. None of them has a legal obligation to sit down with you and explain, clause by clause, what could go wrong after the signing. I'll walk you through these 3 mistakes carefully, one by one, the way I explain them to my own clients when they sit across from me before closing on a purchase. Because understanding these 3 points before signing any paperwork can be the difference between closing the best deal of your life or carrying an expensive problem on your back for years without even knowing exactly where it started. The first mistake happens right at the beginning of the process, often in the first week after the buyer finds the house they want. They visit the property, like what they see, feel that rush to lock in the purchase before someone else shows up, and sign the purchase offer without including an inspection contingency clause. This clause seems like just another bureaucratic line item buried in dozens of pages of contract, but it's actually one of the most important protections you have as a buyer in the United States. It's what guarantees your right to hire a professional inspector to examine the house before the final closing, and to back out of the deal or renegotiate the price if the inspection turns up a serious structural problem. A cracked foundation, hidden leaks behind a wall, an electrical system that doesn't meet safety codes, a burst pipe under the flooring that only shows up once. The water has already ruined a good part of the house. These are exactly the kinds of problems an inspection catches before the purchase. But without a contingency clause in the contract, you lose your right to back out the moment you sign the offer, even if the inspection later finds this kind of problem. I've seen a client discover termites destroying the structure of the house 2 weeks after moving in with the whole family. I've seen another case where the buyer only realized the roof was seriously compromised during the first heavy winter rain, with water pouring through the living room ceiling. In both cases, the contract had already been signed without an inspection contingency. The full loss fell on the buyer's shoulders, because legally there was nothing left to do. The seller had already gotten the money and was long gone. The most frustrating thing about this type of case is that it doesn't pick its victims based on lack of experience. I've represented buyers who had bought homes before, people who work with contracts every day in their own profession, and they still signed without thinking twice, trusting that everything would work out, just because the house looked perfect on the outside and the agent seemed trustworthy. Avoiding this mistake costs nothing beyond a simple request to the agent or attorney. Include the inspection contingency clause before signing any purchase offer. but in the rush to close the deal, afraid of losing the house to another interested buyer, a lot of people skip this step, thinking it's just unnecessary red tape that slows down the process. It isn't. This clause is the only real legal protection you have against buying an expensive problem disguised as your dream home, with no chance to turn back once the ink on the signature has dried. The second mistake usually happens after the home inspection is already behind you, when the buyer thinks the worst is over and starts to relax during the process. At this stage, a lot of people decide not to hire an independent title search. Or worse, decide to skip title insurance altogether just to save a few dollars among all the closing costs. The title search is the process that confirms whether the property is actually free and legally clear to be sold. It checks whether there's any old outstanding debt tied to the property, any forgotten lien, any inheritance dispute between the previous owner's family members that was never resolved, or even a recording error that was never corrected at the local land records office. Without this check, you're simply trusting that everything is fine because the seller said so, or because the agent gave a verbal guarantee. I've seen a client who bought the house, moved in with the family, and 6 months later received a formal lien notice that had existed for years, tied to an old debt from the previous owner that had never been paid off. I've seen another case where a distant relative of the former owner showed up months later claiming a legal share of the property because an inheritance transfer had never been properly recorded in the public records. In neither case had the buyer purchased title insurance. In both cases, the loss became entirely theirs. What's most alarming about this type of mistake is that it doesn't pick its victims based on how experienced they are in the real estate market. I once represented an investor who had bought more than 10 properties over the course of their life. And even they decided to skip title insurance on one of these purchases, because the agent guaranteed everything was fine with the paperwork. A few months after that closing, an old unpaid property tax debt showed up, more than 10 years overdue. Title insurance costs only a small fraction of the total value of the house, paid once on closing day. And it exists for exactly this reason: to protect you against problems that were already hidden in that property's history, long before you even knew the house was for sale. Skipping this step to save a little money at closing is, in practice, betting the entire value of your house on a bet you didn't even know you were making, against a past you had no way of seeing on your own. The third mistake happens right at the very end of the process, on final signing day, when the buyer is already emotionally exhausted from months of negotiating and just wants it all to be over. That's the moment they close the deal without reviewing line by line the closing disclosure, the document that details the exact final terms of the financing and all the fees involved in the purchase. This document is sent to the buyer a few days before closing, specifically to allow time for review. But in practice, most people just skim it, trusting that the numbers have already been checked by the bank, the agent, or their own attorney. The problem is that this document can contain important differences from what was originally agreed on: a slightly higher interest rate, a new administrative fee that wasn't in the original estimate, a prepayment penalty clause that was never mentioned before. I've seen a client realize, on signing day, pen in hand at the closing table, that the loan's interest rate had gone up 0.5 percentage point from what had been pre-approved weeks earlier. I've seen another case where an administrative fee of almost $2,000 appeared out of nowhere in the final document, with no prior explanation from the bank during the entire loan approval process. In both cases, the buyer felt they no longer had room to back out. The move was already scheduled, the movers were already booked, the whole family had already organized their lives around that specific day. Faced with that emotional and practical pressure, a lot of people simply sign, swallow the loss, and only discover months later exactly how much that hidden fee ended up costing over the life of the loan. The most serious part is that U.S. law, through RESPA, guarantees the buyer the right to receive this document with a minimum amount of notice before closing, specifically to allow time for this kind of careful review. The problem isn't a lack of legal time. It's a lack of guidance on exactly what to review, and a lack of nerve to pause the process and question a number that doesn't add up, even while sitting in the closing room with everyone waiting for the signature. Reviewing this document carefully, comparing every number against what was promised in earlier stages of the financing, is the last line of protection you have before taking on a debt that will follow you for the next 20 or 30 years. If you look closely, these three mistakes seem completely different from one another. One happens when signing the initial offer. Another happens during the property title check. The third happens at the exact final moment of signing the financing. Three different stages of the buying process, at three different points in the negotiation. But there's something that connects all three, and it's always the same thing. In none of these three cases did the buyer have independent legal guidance before signing. They relied on the agent, who works to close the sale. They relied on the bank, which works to release the financing and collect interest. They even relied on their own confidence that everything's fine because the house looked good and the people involved seemed to be acting in good faith. But none of these people had, as part of their professional role, an obligation to protect that buyer's interests exclusively. That's exactly where a real estate attorney comes into the story in a different way. Not as someone who shows up after the problem has already happened, trying to fix what's already been signed. It's someone who should be present before each of these three decisions. Reviewing the inspection contingency clause before the offer is signed, checking the results of the title search before title insurance is waived, and reading the closing disclosure line by line alongside the buyer before the pen touches the paper for the last time. The difference between the clients I've had who suffered real losses and other clients who went through the exact same steps without any problems was never luck. It was having someone by their side at each of these three moments, asking the right question before the signature, not after. Buying a house is usually the biggest financial decision of a person's life in the United States. And yet, it's one of the few processes of that size where so many people walk through it alone, relying only on professionals who have other interests along the way. The three mistakes I've shown you here don't happen because people are careless. They happen because no one stops to explain, at the right moment, exactly what's at stake with each signature. If you've made it this far, you already know more about protecting yourself when buying a home than most people who sign a contract without a second thought. Keep these 3 points in mind before your next signing and protect your money and your family from a loss that can be avoided. If this video helped you, hit like. Now it helps this video reach more people who need to hear it. And subscribe to the channel, because every week I bring you real cases to help you protect yourself.